So a settlement agreement's a way to mutually bring about the end of an employee's employment with the business, and they're used in various different situations. Sometimes they're used as an alternative to redundancy, or they can be used as a way to resolve amicably any sort of dispute that somebody's having with their employer.
Typically, people will be offered a settlement agreement for quite a few reasons. That could be linked to performance. So as an alternative to going down sort of a performance improvement plan, they can be offered this settlement agreement instead to resolve their employment. It can also be used quite commonly for sort of as an instead of doing a redundancy procedure as well as. So that's, I would say, typically sort of when we would see them.
So we would have a meeting with the client once we'd completed all their onboarding. It generally takes about an hour, and it's split into two halves, really. So in the first half, we would go through all of the background with them. We'd find out whether they've got any potential employment claims against their employer, such as unfair dismissal, discrimination, unlawful deductions of wages. And the reason that we need to do that is because when you sign a settlement agreement, you waive all of those claims against your employer. So it's important to know what you're giving up when you sign an agreement. And then in the second half of the meeting, we'll go through the actual agreement itself and all of the terms that are contained in there.
It's tricky. So we do get often asked sort of what is a good offer, or whether, you know, a particular person has been given a good settlement agreement. But it's one of these things, unfortunately, that's just it's difficult to say, especially just on that first phone call. There are going to be loads of variables at play as to what would constitute a good offer for that person. So instead of, I think, sort of going through on that phone call sort of what their potential sort of settlement agreement could be worth, it's better, as you said, to go over in that meeting what potential claims they may have, and almost then use that as a bit of a precursor as to what that settlement agreement could be worth.
So it's quite common that an employer will make a contribution towards the legal fees. The amounts vary from employer to employer, but because it's a legal requirement for them to take advice, it's common practice for those to be paid by the employer. So there are a lot of different things in the agreement. So the key things are the compensation payment that you're going to be receiving, any payment in lieu of notice, whether you're working that or if you are being paid for it, accrued and untaken holiday, confidentiality, restricted governance. There's so much that goes into it, and we can explain all of that to you during our meeting.
Yeah, I think as well as is that something that's quite important that often gets missed as well when employees have this conversation with their employers is what they call an entire agreement clause. Now, what often is the case is that we'll have these meetings with the clients and they've been told that they're going to receive sort of extra things outside of this agreement, where we would typically need to make them aware that because of an entire agreement clause, anything that's been promised outside of that agreement isn't actually going to be binding.
Yeah.
So we need to make them fully aware that everything that you've been promised is inside that agreement, otherwise it's likely not going to.
Yeah, I agree. That's very important as well. And the fact that the agreement doesn't actually become binding until it's been signed by all of the parties. So a misconception is that by saying you're willing to enter into an agreement is proof that you've accepted it and it's done there, but it's not. It's not until the full agreement's been negotiated and signed where you're actually bound by any of its terms.